How are injuries proven?
Oh, okay. We're getting right into it.
Yeah.
How are injuries proven? So, without evidence of an injury, the assumption is basically the injury didn't occur. So we always have to remember that the burden of proof is on us as the plaintiffs, as the ones bringing the case. So when we're representing the injured person, it's our burden to prove the extent of the injury. So what we need is evidence, right? And the most common form of evidence of an injury is the medical records. So the big takeaway is if you're hurt, you really need to go to a doctor. I can't tell you how many times I've talked to people and they say, oh, my back has been hurting for weeks. Okay, well, did you go to the doctor? No, I wasn't sure if I could. You can. If you're hurt, you need to go see a doctor. That's the only way that anyone is ever going to be able to tell that you were in fact hurt. If there's not evidence of it, then it didn't happen. So the first thing is getting to the doctor. Anecdotally, there's also ways that we can kind of help corroborate or prove the extent of the injury, perhaps with video or pictures or even third-party testimony. Oftentimes a spouse or a loved one that observes the way an injury has affected someone can be in a very effective person to give testimony about how that injury has actually affected that person. But the first thing is really the medical records. Always make sure, we need good imaging, for instance, if it's a disc bulge or a broken bone or something that can be seen with imaging, whether that's an MRI or a CT scan or an X-ray, that requires going to see the right professionals, though. And that's really one way that we can help, because a lot of people don't understand they don't understand what their rights are. They don't understand that they can go to the doctor. They don't understand that they don't need, and we talked about this in our last podcast. Yeah. You were discussing this. Folks don't understand that they don't need approval. It's not like a workers' comp claim where you might need approval. And a third-party liability claim, if you're hurt, you go see a doctor. If you need to go see a back doctor or you hurt your back, go to an orthopedic, go to a neurologist, go see a chiropractor, whatever the case may be. Funnel yourself into the right treatment that you think you need. Listen to your body. And then it's our job to pick up the breadcrumbs, go get all those medical records that prove the injury, and that's our evidence.
Okay. So basically kind of treating it like any other injury that you may sustain. So if you were working at your house and you fell and injured yourself or something, just treating it like I'm injured, I'm going to go to the doctor.
So I don't mean to interrupt, but the problem that we run into is when the reality doesn't match what the records say. So someone may get through physical therapy, for instance, and they're released, not because they're better, but because the physical therapist says, well, there's nothing else I can do for you. And then the claimant thinks, okay, that's it. There's nothing anyone else can do. I'm done. And then you find out, weeks or a month or two later that they're still in a lot of pain and they still can't work. But now there's a gap in medical treatment where they didn't go to the doctor because they thought, well, there's nothing else anyone else can do for me. Now, all of a sudden, we have a reality that someone's remains injured, but the evidence that we have is that the medical records ended. And when the medical records end, the assumption is that that person got better. So it's important to follow up even if there's lingering pain and you don't think that there's anything anyone can do for you, there still has to be evidence of the record or on the record so that we can prove the injury. So it's important to go back to the doctor just to discuss that if you need to.
Okay. So like in a hypothetical, let's say someone is in an accident and an auto accident and is taken to the emergency room and I'm not going to say there's nothing wrong with them, but there's nothing that needs immediate help, such as surgery and things like that. And they're discharged and told to follow up with their primary care physician if they continue to have pain. So should someone do that? I know a lot of clients are worried about unnecessarily going to the doctor, and we don't want anybody to unnecessarily go to the doctor. But, what should someone do in that kind of situation if they're not having physical therapy or they're not having, surgery or anything like that? Should they follow up with their primary care physician or should they try to seek out, a specialist or what should they do?
Well, first thing, I always tell people to listen to their body. And your body will tell you what's wrong. And you know the difference between, soreness and being injured. At least most people do. And if you do have a primary care physician, it's a good idea to start there and let them be the quarterback. So that's there's pros and cons to that, right? The pro is, especially in a system that has like an Atrium or a Novant, for instance, we see a lot locally. It's very convenient for a general care physician to send someone to a specialist because they're all under the same roof. They're all in the same network.
Yeah.
They all take the same insurance. It's a little bit more difficult when you don't have that. But it's important that that general care physician be involved and be able to quarterback it. The con is, what I just don't like to see is when someone starts with a general care physician and the default is, here, take a bunch of pain medication, come back in 2 months. I'll give you a month and then another refill. Come back in 2 months, and if you're still in pain, then we'll figure out something to do. And rightly, that person might listen to their doctor. And then all of a sudden, 60 days later, the pain medication runs out, and they're like, oh, I'm still in a lot of pain. This pain medication was masking it, but I haven't gotten better. But now there's a 2-month gap in treatment. Mm-hmm. And unfortunately, the reality is liability carriers just love to try to take advantage of a gap in treatment and use it as a means to try to devalue the case, even if there's a perfectly logical explanation for it, like there is in that hypothetical.
Okay.